Imagine you just finished paying at Walmart. Your cart is full.
You have groceries, shampoo, dog food, and one big item sitting loose on the bottom rack. You roll toward the exit, ready to go home, and an employee steps forward and says, "Receipt, please." For a second, it feels like a command. People behind you slow down. A few people stare. Now your brain starts racing. Do you have to stop? Can they block the door? Can they touch your cart? And if you keep walking, did you just break the law? That moment matters, because a lot of people assume two things that are not actually the same. They assume store policy is the same as law, and they assume a private employee has the same power as a police officer. Neither assumption is always true. By the end of this video, you'll understand the rule most people miss, why the answer changes depending on the facts, and the small mistake that can turn a simple receipt request into a much bigger problem. The short answer is this.
Walmart can absolutely ask to see your receipt. The harder question is whether Walmart can legally stop you if you say no.
And the honest legal answer is not a clean yes or no. In many ordinary situations, a routine receipt check is just that, a request. But if store staff has enough reason to think merchandise was not paid for, the law in many states gives merchants limited power to detain a person for a short time and investigate. That is why two people can have totally different experiences at the same store and both walk away thinking the law is on their side.
Here is where many people get confused. They hear the word rights and jump straight to the Constitution.
But a regular Walmart employee is not the government. That matters. The Fourth Amendment is mainly about unreasonable searches and seizures by the government, not by an ordinary store worker standing near the sliding doors. So if a greeter asks for your receipt, that usually is not a Fourth Amendment issue in the same way a police search would be.
The legal fight is more often about private property, store policies, and something called false imprisonment if a person is held without lawful grounds. False imprisonment sounds dramatic, but the idea is simple.
It means someone intentionally restrains another person without legal authority. In plain English, if a store employee really stops you and the law did not justify it, the store can have a problem. But stores are not powerless. The law has long recognized a limited exception, often called shopkeeper's privilege.
That rule exists because stores are allowed to protect their merchandise. So the law tries to balance two things at once.
One is your freedom to leave. The other is a merchant's right to investigate actual suspected theft. That balance is the key to the whole video. Shopkeeper's privilege is not a blank check. It does not mean a store can stop anyone, anytime, for any reason. In general, the rule is narrower than people think.
The store usually needs a real reason to suspect theft, not just a general wish to check every customer. And even when the store does have lawful grounds, the detention is supposed to be reasonable in time and reasonable in manner.
In other words, even when a stop is allowed, the way it is done still matters. So let's slow this down and make it practical. There are really three different situations people mix together. First, there's the routine exit request. That is when an employee says, "Can I see your receipt?" with no sign of a specific theft concern.
Second, there is a suspicion-based stop. That is when staff believes something may have been stolen, like an item that was not scanned, merchandise hidden in a bag, a tag switch, or a self-checkout problem caught on camera.
Third, there's the membership club situation, which works differently because the customer agreed to certain rules as part of membership. If you don't separate those three situations, the topic never makes sense. Start with the easiest one. A routine request is not automatically the same as a legal detention. If an employee is simply asking, that does not always mean you're legally required to comply. In many states, the stronger legal power kicks in only when the merchant has some level of reasonable grounds, reasonable belief, or probable cause to think theft happened or was attempted. That wording changes by state, but the basic idea is similar. The store usually needs more than we like checking receipts at the door. So if the question is, does every Walmart shopper have a universal legal duty to stop for a random receipt check? The answer is usually much weaker than people think.
But that is only part of the story. People often take that idea too far and turn it into, I can always ignore them and keep walking.
That is not a smart way to understand the law. A routine request may be one thing, a detention is another, and the facts can change in seconds. If you have a loose television in your cart, if an alarm sounds, if loss prevention watched a missed scan at self-checkout, or if a worker saw unpaid merchandise tucked under other items, the store may argue it had enough reason to stop you. That is when the conversation shifts from courtesy to legal justification. California gives a helpful example. Its law says a merchant may detain a person for a reasonable time, in a reasonable manner, when the merchant has probable cause to believe the person is trying to unlawfully take or has taken merchandise. That matters for two reasons. First, it shows the store does not need magic words. It needs actual cause. Second, it shows the stop has limits. Reasonable time and reasonable manner are not throwaway phrases. They are the legal breaks. A store cannot turn a brief investigation into whatever it wants just because an employee feels suspicious. Texas uses similar logic, but with slightly different wording. Texas law says a person who reasonably believes someone has stolen or is attempting to steal property is privileged to detain that person in a reasonable manner and for a reasonable time to investigate ownership of the property. New York also has a version of this idea.
Its statute gives a defense when a person is detained in a reasonable manner for not more than a reasonable time, and the store had reasonable grounds to believe the person was committing or attempting larceny. Notice the pattern.
Different state, same backbone. Real grounds, reasonable conduct, limited duration. And that leads to the question viewers really care about. What counts as being stopped? Because many people hear that word and picture handcuffs, locked rooms, or being dragged back inside. Illegal detention can be less dramatic than that. If an employee physically blocks the exit, grabs the cart, takes your property, uses force, or makes it clear that you're not free to leave, that starts to look a lot more like a detention than a simple request. On the other hand, if someone politely asks to see the receipt and you're still free to keep moving, that may be nothing more than a voluntary interaction. This is why body language matters, tone matters, physical contact matters. The same 4-second moment at the door can look harmless in one case and legally risky in another. A smile and a request are one thing. A hand on the cart and a command to stay put are different. That difference becomes important if a case ever gets reviewed later. Courts do not just ask what the employee wanted. They also look at what actually happened to the customer and whether the store acted reasonably under the circumstances. Now let's answer the title directly. Can Walmart legally stop you at the exit? Yes, sometimes. No, not always.
If Walmart staff has lawful grounds under state law to suspect shoplifting, then a limited detention may be allowed. If staff does not have that kind of basis and is just doing a general receipt check, the legal power is much less clear. And in many ordinary retail settings, the customer may not be under a standalone legal duty to stop just because a person at the door asked.
That is why the most accurate answer is not emotional, it is conditional. Here's another detail many people miss. Refusing to show a receipt is not the same thing as admitting guilt.
But refusing does not magically freeze the facts, either. In a real-world encounter, your refusal becomes part of the overall picture.
By itself, it may not prove theft, but combined with other facts, it can add to the store's suspicion. That is one reason lawyers often tell people not to treat these moments like a viral gotcha video opportunity. The law may be on your side in one narrow sense, but your behavior in the doorway can still make the situation worse.
Suppose your receipt is in your hand, the employee asks to see it, and you simply keep walking without saying a word. One outcome is that nothing happens.
Another is that a loss prevention employee follows you and asks again. Another is that the store interprets the situation through the lens of other facts you may not even know about, like a register alert or camera review. The legal point here is not that silence is illegal. It is that real encounters are messy.
The law is built around facts, not slogans. And people get into trouble when they act as if one sentence they heard online settles every situation.
There is also a big difference between checking a receipt and searching a person. Those are not the same event. A receipt check is usually the lighter request. A physical search is more serious. In California, for example, the law specifically discusses limited searches of packages, shopping bags, handbags, or other property in the immediate possession of a detained person when there is probable cause and after refusal to surrender suspected items. It also says clothing worn by the person is not included in that search rule. That shows how careful the law can get. Even when detention is allowed, the scope of a search can still be limited. That means you should be careful with broad claims like a store can never search you or a store can search anything at once. Both can be misleading. States differ, facts differ, and the level of suspicion matters. A quick glance at a receipt is one thing. Demanding to search clothing is another. Opening a purse without lawful grounds is another. Asking you to voluntarily show what is in a shopping bag is different from using force to do it. The deeper you go into a customer's personal space, the more legally sensitive the situation becomes.
Here's where warehouse clubs change the picture. Sam's Club and Costco are useful comparisons because they show how contract can matter.
Sam's Club's terms say the club may inspect or electronically scan your merchandise, cart, and receipt when you exit. Costco says receipt verification at the door is standard practice. That is not just random store habit. That is part of the membership relationship. When you join a warehouse club, you agree to terms that are different from walking into a regular open retail store. So people who say, I can refuse at Costco because I refused once at Walmart, are mixing two different legal setups. That comparison actually helps explain Walmart. A regular Walmart is not the same as a membership warehouse. You generally do not sign a membership contract promising receipt inspection just to buy cereal and laundry soap at Walmart. So the legal conversation at Walmart usually turns on suspicion and state law, not on a membership agreement.
That does not mean Walmart has no rights. It means the source of the store's power is different.
One situation is more about contract. The other is more about shopkeeper's privilege and the facts known to the store in that moment. Now let's deal with a common myth. Some people say, if they touch your cart, it's automatically illegal. That is too broad. Some state laws allow reasonable, non-deadly force to prevent escape or protect property when the legal standard for detention has been met. But the important words are reasonable and lawful grounds. A store employee does not get unlimited force just because they suspect something. Overreacting can expose the store to serious risk. On the flip side, a customer who turns the situation physical can also create new problems fast. That is why the safest advice in almost every version of this story is the boring advice. Stay calm. Another myth is that if Walmart stops you, you should instantly argue constitutional law in the doorway. That usually does not help.
If this is just a routine request and you choose to comply, the encounter may end in 5 seconds. If you choose not to comply, do it calmly, not theatrically.
If staff says you are being detained, the most useful practical question is simple. Am I free to leave? If they say yes, that tells you something. If they say no, then you know the store is claiming legal justification for a detention. At that point, the smart move is not to escalate physically. The smart move is to pay attention. Pay attention to who is speaking. Is it a greeter, a manager?
Asset protection? An off-duty police officer working security?
Those details can matter. The more a situation begins to involve police or someone acting under police authority, the more the legal terrain can change. But many exit encounters never get that far. They stay in the private store world. That is why it is important not to mash every scenario together. A greeter at the door, a loss prevention officer in plain clothes, and an on-duty officer are not all standing on the same legal ground. So what should you actually do if this happens? First, keep your receipt accessible, especially if you bought an unbagged item. That is not about surrendering your rights. It is about avoiding a pointless scene. Second, if asked, decide whether this is a hill you really want to die on. A 5-second receipt glance is often the easiest path. Third, if you do refuse, stay polite. No sarcasm, no shoving, no trying to make content for social media. Fourth, if the employee says you're being detained, ask why. Fifth, do not run.
Running can make a bad situation look worse and may become one of the very facts the store later points to.
There's another detail that often gets overlooked. Even when a customer is eventually found to have done nothing wrong, that does not automatically mean the store acted illegally. The law often asks whether the store acted reasonably based on what it knew at the time. A mistaken suspicion can still be legally protected if the merchant had the required grounds and handled the stop reasonably.
But if the store had no real basis, or dragged things out, or used excessive force, or humiliated the person in a way that went beyond what was needed, then the store may lose the protection it thought it had. That is why false imprisonment cases turn so much on details. How long were you held? Where?
Did anyone block the exit? Did they touch you? Did they accuse you in front of other shoppers? Did they look at the receipt and immediately see the item was paid for, but keep you there anyway? Did they search something they had no right to search? Those facts matter more than dramatic one-liners online. The public loves broad rules. The legal system loves specifics. And here's the practical lesson most people remember best.
There's a big difference between you don't have to show your receipt in every routine situation and Walmart can never stop you. The first statement may be broadly true in many non-membership retail situations, depending on the state and the facts. The second statement is clearly too absolute.
Stores are not helpless. When employees have lawful grounds to suspect theft, many state laws give them a narrow but real power to investigate. That is the part people leave out when they reduce this whole topic to a meme. Suppose you are completely innocent, but the self-checkout missed a scan because the item sat under another bag. Suppose you paid for the item, but the receipt is hard to read, and the employee thinks something is off. Suppose a cashier error made it look like part of a 2-pack was not paid for.
These situations are exactly why the law tries to create a middle zone between total freedom and total store control. The merchant gets a limited chance to investigate. The customer still keeps legal protections against unreasonable detention.
Neither side gets everything. So if you want the most honest answer possible, here it is. Walmart can ask to see your receipt. A routine request does not automatically mean you are legally required to stop. But if Walmart has enough reason under your state's law to believe theft happened or was attempted, Walmart may have legal authority to detain you briefly and reasonably to investigate. The exact wording changes by state.
California talks about probable cause. Texas uses reasonable belief. New York says reasonable grounds.
Different labels, similar structure. The store needs more than a vibe. And the stop still has limits. And if you remember only one thing from this video, make it this. Do not confuse what is voluntary with what is wise. In some cases, you may be free to decline a routine receipt check.
But turning that moment into a confrontation can create new facts, new suspicion, and new risk. The law does not reward drama. It rewards reasonableness.
That goes for the store, and it goes for you too. So the next time you hear somebody say, Walmart can't stop you, or you always have to show your receipt, slow down. Both statements flatten a more complicated truth. The real answer depends on whether this is a request or a detention, whether the store has real grounds for suspicion, whether the stop is reasonable, and whether you are in a regular retail store or a membership club. Once you understand those moving parts, the issue stops feeling mysterious. And maybe that is the best reason to know this before it ever happens to you. Most legal trouble does not begin with a dramatic courtroom moment. It begins with a tired person at a doorway making a fast decision under pressure. If you understand the difference between store policy, state law, and actual detention, you are much less likely to make that decision badly. You do not need to be paranoid. You do not need to be combative. You just need to know what the law is really trying to balance. Because in the end, this topic is not really about a receipt. It is about power at the edge of a doorway. How much power a store has, how much freedom a customer has, and what happens when those two things collide for 10 awkward seconds in public. If you know the rules, those 10 seconds become much easier to handle.
And that is exactly the kind of knowledge you want before you ever need it.